Welcome to FedSoc Forums, a podcast of the Federalist Society's practice groups. I'm Nate Kazmarek, Vice President and Director of Practice Groups at the Federalist Society. For exclusive access to live recordings of FedSoc Forum programs, become a Federalist Society member today at fedsoc.org.
Hello, everyone, and welcome to this Federalist Society virtual event. My name is Marco J. Lloyd, and I'm the Assistant Director of Practice Groups at the Federalist Society. Today, we're excited to host the webinar, Should a Labor Court Replace the Adjudicative Function of the NLRB, featuring Professor Sam Estreicher, Richard Griffin, Professor David Sherwyn, and Gwynne Taubman. Sam Estreicher is the Dwight D. Opperman Professor of Law and Director of the Center for Labor at New York University School of Law. He is a nationally preeminent scholar in U.S. and international comparative labor and employment law, authoring more than a dozen books and 200 articles. Richard Griffin is of counsel at the Washington, D.C. law firm of Bredhoff and Kaiser and has practiced labor law for more than 36 years. Prior to joining the firm, he served as a board member and later general counsel of the NLRB, being nominated by President Obama and confirmed by the U.S. Senate. David Sherwyn is a John and Melissa Seriale Professor of Hospitality, Human Resources, and a Professor of Law at Cornell. Professor of Law at Cornell, Peter and Stephanie Nolan School of Hotel Administration. He is also the Academic Director of the Cornell Center for Innovative Hospitality, Labor and Employment Relations, and a Research Fellow at the Center for Labor and Employment Law at New York University School of Law. Gwynne Taubman is a staff attorney for the National Right to Work Legal Defense and Education Foundation, where he's worked for over 40 years, litigating cases for employees under a variety of federal and state labor statutes. Recently, he has concentrated on litigation before the NLRB, bringing many groundbreaking cases to protect employee rights. Our moderator today is Roger King. Roger is Senior Labor and Employment Counsel for the HR Policy Association. He's also served as a partner at Jones Day, a captain and legal services officer in the United States Air Force, and a professional staff counsel for the U.S. Senate Labor Committee. He has testified before Congress and represented employers in many high-profile labor and employment law cases, including co-counseling the winning side in the landmark Supreme Court case, Noel Canning. If you'd like to learn more about today's speakers, their full bios can be viewed on our website, fedsoc.org. If you have a question at any point in today's program, please enter into the Q&A function at the bottom of your Zoom window. We will do our best to answer as many as we can. Finally, I'll note that, as always, the Federalist Society takes no position on particular legal or public policy issues, and all expressions of opinion are those of the speakers. With that, thank you all for joining us today, and the floor is yours.
Thank you, Marco, and thank you for everyone that's joining us today. The future of the National Relations Board is certainly a subject for conversation. Over the past decade, we've seen an increasingly oscillation of policy, or to use Professor Estreicher's term, extreme policy oscillation from one administration to the other, where the law under the National Relations Act undergoes substantial change. We've also seen an increasing skepticism of the federal courts of appeal regarding the jurisprudence under the National Labor Relations Act, given such wide policy swings and such apparent partisan political influence on the outcome of cases pending before the board, particularly important policy cases. We've also heard increasing complaints from all stakeholders under the National Labor Relations Act, whether it be labor, management, or employees, regarding such extreme policy oscillation and the difficulty of making predictions and giving advice, etc., as to the state of the law under the Act. We also have seen recently the very partisan influence on the board in major policy decisions through articles, presentations, and the like. Pardon me, I have a bad cough. And finally, we have the termination of board member Gwynne Wilcox. So the issue is, do we need a replacement for the board? Sam, why don't you start us off with an Article 1 proposal?
Before I do that, I just want to lay the groundwork a little bit. The Supreme Court, I do not like to make predictions that can be verified or invalidated in the short term. But I'm going to make a prediction now against my instincts that I do not think that a 1935 case called Humphrey's Executor is long for this world. In Humphrey's Executor, the Supreme Court unanimously held that the Federal Trade Commission structure was constitutional, even though the president could not remove at will the members of the commission. This was a unanimous decision by one of the arch conservatives on the court, Justice Sutherland. The Supreme Court, and that is the decision that sort of led to the assumption of everyone in the field that these multi-member administrative agencies were constitutional, even though the members of the commissions, the members of the agency had removal protection. They could only be removed for cause. That was also true of the NLRB. We've now seen a revolution in the Supreme Court, raising questions about whether or not it's consistent with Article 2 of the Constitution, which vests the entire executive power in the president, whether it's consistent with Article 2 to shield principal officers of the United States, and all the members of the NLRB are principal officers of the United States, shield them from at-will removal by the president. Now, in addition to all the factors that Roger mentioned about the policy oscillation problem, the problem it poses for compliance, for counseling compliance, we've also got this problem. It's not clear that the structure of the NLRB will be held constitutional. The court hasn't granted the case yet, but on an emergency application involving the removal of Gwynne Wilcox, who was a member of the NLRB, a majority of the court clearly said that the government, U.S. government, is likely to win, as they had to in deciding to stay an injunction. It's likely to win on the merits that these heads of these agencies, this agency and the Merit System Protections Board, the heads of those agencies need to be removable at will by the president. And that's not a ruling on the merits, but it's a pretty good harbinger of what's likely to happen. So our proposal, and we don't know if this will work, but we think it is a credible proposal, and that is to strip the NLRB of its law enforcement functions, to make it a purely adjudicatory body. That would mean either giving the general counsel or some other, maybe someone in the Department of Labor, by statute, this would require a new statute, to give the law enforcement functions and the affirmative prosecution functions to an officer of the United States removable by the president. Could be the general counsel, who is currently removable by the president at will, or could be someone else. That would include rulemaking, which, even though I've urged the board for the last 45 years to do, they're not inclined to engage in a lot of rulemaking for good reasons that have ensued. It would also mean they would no longer supervise the regional directors, which I don't think they've actually done. There was a theoretical appeal to the board. That's something that should be lodged entirely with the general counsel or some other body. That would also mean that they would no longer supervise applications for 10J relief. That too would be with the general counsel or some other body, removable at will by the president. This would be an adjudicatory body. It would hear appeals from unfair labor practice cases, which will be litigated before administrative law judges, and hear appeals from final representation cases, which would involve, we haven't worked out the details, but would certainly involve certification decisions and maybe other decisions in our cases. So the general counsel would supervise the regional directors. The president would, or the general counsel would appoint the regional directors, but there would be an appeal from those decisions to the labor court. The labor court would be comprised of 6 members. They would sit for, I believe it's 6-year terms, staggered terms, so that by the end of the 2 or 3 months after the midterm elections, the new president would be able to appoint a majority of the court. The court would consist, I said, of 6 members, 2 Ds, 2 Democrats, 2 Republicans, and 2 independents. The independent slot was a difficult one. We've given it a lot of thought. And the basic criteria that we've set in our proposal, which we think will inform what the Senate will do, hopefully, in making confirmation decisions, will be that these are folks that have not represented management or labor interests, or not have participated in amicus nor in any other way in support of management or labor interests for 6 years, and also, prior to the nomination, also have a reputation for essential even-handedness, and those would be the neutral members of the court. The court would sit in panels of 3, but any member of the panel could seek en banc consideration, or as the full 6 members of the court. It would take 4 members of the court to overturn precedent. It could not be overturned by the panel of 3, or it would require 4 members, which would include 1 independent, at least 1 independent. That's the basic idea. Review would be had from the decisions of the labor court, but it would not be review at the behest of the general counsel. It would be review at the behest either of the union or the employer, or if it's a case that involves employees, or of the employees. There would be a new office of the solicitor of the board, who would be appointed by a solicitor of the court, who would be appointed by the court, and who would intervene in cases to represent the board's issues. If the court took, the court's issues. If the court took more than 1 year to process an appeal, there would be an immediate right of review by an aggrieved party. I assume it's to the district courts. Now we set out in the statute. So that's the basic idea. Divorce the board from its law enforcement functions, which would be handled by politically removable officers of the United States. Create a setup whereby you would have to have the buy-in of at least one of the neutral members of the board to overturn precedent, which we think will curb, will not eliminate policy oscillation, which we think is a good thing for the administration of the board. And we're not tying the hands of the new president, because the new president will be able to appoint a majority of the court 2 or 3 of the midterm elections. So we've thought through a lot of this. I'm sure there are problems with it, but the question you should all ask yourselves is, if not something like this, what else? We think it's highly undesirable for labor policy and for other reasons to continue with members of an NLRB that are removable by the president. Now, sure, if your president is in power, you're very happy with that. But what's good for the goose will be also good for the gander. We'll have tremendous uncertainty. Right now, as Roger pointed out, it's hard to convince employers or unions in hard cases that they should stick by the board decision, because many of these cases are up for grabs each year. But we think that would not be a desirable. I think it would undermine the credibility of the board. So another alternative is to have Article 3 judges do that. Article 3 judges sit for lifetime terms. We think it's highly unlikely. We're not against the Article 3 route, by the way. We think it's highly unlikely that Congress will create Article 3 positions for narrow purpose agencies like this, because we'll not stop with the board, the Merit Systems Protection Board, all the various agencies. It's just not, Congress is not likely to do it. It would demean, I would believe, the currency of being an Article 3 judge, because everyone would be, there'd be an enormous judiciary, very close to a Latin American model judiciary. So we don't think that's a desirable alternative.
So Sam, let me stop you there. Excellent analysis. Just full disclosure, I am serving as the moderator for this panel, but I, with Sam and with David, am the co-researcher and background proposer, if you will, of the Article 1 court. But I'm not going to undertake any discussion today as a proponent. I will stay neutral as a moderator.
The Supreme Court, if I just make one more point, Roger.
Sure.
Who knows what the court is going to do? But if the court goes down the route that all adjudication in the United States has to be handled by either a politically removable body or Article III judges, it will mean the end of Article I courts, which have been endorsed by the Supreme Court. They've been around for a long time. Think of the tax court, the patent court, the veterans court, military courts. They can't all possibly be handled by Article III. And if the president can remove adjudicators, in my view, there's no integrity to the adjudicative body. If he can remove them at will, certainly the president can remove for cause, and the president can remove when the term is up. But to remove at will, people will understand they've got to do the president's bidding, and there's no integrity in that adjudicative body.
Thank you, Sam. Let me turn to David just for a moment. David, I know in conversations with you, you and Sam and myself have looked at other approaches, the EEOC model, for example. And also we've had discussions about whether there really are qualified so-called independents available. Would you speak to both those issues and also supplement anything you wish regarding Sam's outline?
Yes. Thanks, Roger. Thanks, Sam. I think that the first thing, and I think Sam laid it out really well, that, the question that people would say is, so what? Why are you doing this? The law, the board is 90 years old. Why are we now doing this seemingly radical change? And as Sam referred to with Humphrey's executor and just what's going on with the firing of Gwynne Wilcox, what we're seeing is that there's a real possibility that either now or in the near future, the current structure of the board will just be either unlawful or untenable. So something needs to be done. And when we look at what the problems are, problem number one, is the current structure lawful? It looks like it may not be. Problem number two is, the oscillation or the flip-flops, as one member of my board once said in an exasperated moment, I just wish that every 4 or 8 years we would go from the 40 to the 40 instead of the goal line to the goal line. That employers and unions need some level of certainty, and that's that's problematic with where we are right now. And then there's just the cynicism that comes with the current structure of the 3-2 majority and the law flipping back and forth, and the question of the adjudicators are also making rules, and that leads the parties to have to not have the type of respect that they should have for a government agency, for an adjudicating agency like the board. So we looked and said, there is a problem. How do we fix? And as Sam said, one thing to do is to take the adjudication out of the structure of the board. The fact now is that the general counsel's office in the board, and we've got Dick here, a former member and former general counsel, so he can speak to this much more intelligently than me, but the general counsel of the board is the colleague of the board at times and is now an advocate in front of the board. And that creates some levels of concern on the parties. And again, this level of cynicism. Now we've got a court that stands to adjudicate that is not under the same umbrella or the same employ as the general counsel and the regional directors who operate day to day. So those are our reasons for doing this. So how do we make it work? And as Sam referred or stated, yes, we could think about these lifetime appointments, but they're problematic for many reasons. The largest one is, would Congress ever approve it, and how ugly that can get? So we came together and said 6-year terms staggered. And if you just do the basic arithmetic, you'll see that every president through time will be able to make his or her mark on this court, but they wouldn't be able to start from scratch and create the court in their image, and then 4 or 8 years later have someone created in another image. So that's level one, is that the 2 years staggered allows continuity but also allows the new president, the current president, to have huge influence. Our biggest concern was the neutrals. We have had for 90 years sort of the unwritten agreement that the president will have a 3-2 majority. And at least perception is that the majority is partisan, and that what we have is, and if we can look at it, we can see I'll just start on Obama because I don't want to go all the way back to Carter, or more, but the Obama board overturned a lot of things from the Bush board, and the Trump board overturned Obama, and Biden overturned Trump, and here we go again. So we're looking to say, okay, we're not going to have such a drastic flip, and instead some continuity. We will have 4 members who are members of a political party, Republicans or Democrats, 2 and 2. The big issue was, who are the neutrals? And it was a concern because initially it was, well, they can't have practiced law on either side. They can't even be a registered Republican or Democrat. And then we realized, wait a second, anyone qualified and interested in this work is not going to be somebody who has essentially withdrawn from the political process. And in many states, you can't vote in a primary unless you're registered in a party. So why would we want somebody who is not interested in politics and somehow they're going to be disinterested to do this job? So that didn't make sense. But when we looked at neutrals, we realized that there are, whether they're judges, whether they are arbitrators, or other folks that are not actively practicing representing employers or representing unions, that there are people who are well known in the field that and have made their careers as neutrals. And having those folks on the board can mitigate the extremes and allow the parties to believe that everybody has a fair shot in every administration, as opposed to, well, I'm in the minority, I got to wait 4 or 8 to be in the majority. And that is untenable, and we're hoping to correct that. Thanks, Roger.
Yeah, excellent, David. We have Richard Griffin with us. Dick is one of the best known and most articulate individuals that I'm aware of with respect to matters under the National Labor Relations Act. Outstanding scholar, had great government service, as noted as a board member and general counsel, and just brings a wealth of private practice experience also. So, Dick, your reaction to an Article 1 court replacing the current 5-member board?
Yeah, Roger, thank you for that overly effusive and largely inaccurate introduction.
It's all accurate. Come on.
Let me say, first of all, that this is a rare instance where there is a point that I am in agreement with you and David and Sam on, and that is
that hurts. That hurts. Go ahead.
I'm being a little bit facetious, but not too much. And that is the importance of the quasi-judicial officers deciding unfair labor practice cases and representation cases at the appellate level, for them to have independence and not be looking over their shoulder. I agree with Sam's point that that's an untenable position if the president can fire those folks willy-nilly for a good reason, for a bad reason, for no reason at all, or as he just fired the head of the Bureau of Labor Statistics because there was a result he didn't like. So my point, though, is that I think this proposal puts the cart before the horse because while Sam believes Humphrey's executor is not long for this world, and I think the consensus may well be that Humphrey's executor is not long for this world, I think it's important for all of those of us who believe the point that Sam made so forcefully to stand up for the proposition that for-cause limitations on the president's authority are constitutional. And whether it's in the case of Gwynne Wilcox, whether it's in the pending case of the FTC commissioner, whether it's in the likely upcoming case of the head of the Federal Reserve, I think it's very important for us to take that position. And I would say that part of the reason it's important is because it is very much contrary to the position that's being taken broadly in corporate America, as demonstrated by a recent letter from the coalition, the euphemistically named, in my opinion, Coalition for a Democratic Workplace, their submission to the Attorney General, Pamela Bondi, that she should, in her capacity as the unitary executive, President Trump's word on the law and the executive branch, should direct the overturning of a series of precedents, and that she has that authority. This unitary executive theory, which is the basis for the discharge of Gwynne Wilcox, has no bounds. The position of the government, as expressed in these cases, is that if you are in the executive branch, you are performing an executive function, and you are dischargeable by the president on his whim for a good reason, a bad reason, no reason at all. So should the Wilcox case, or the case involving the FTC commissioner, or whatever case gets to the Supreme Court on the Humphreys executive question, should the Supreme Court adopt that expansive view of presidential authority, with all due respect to the efforts here, I think they are likely to be doomed. And if the Supreme Court says you can't cabin the president's executive authority, and that anybody who is in the executive branch is exercising executive authority, no matter how quasi-judicial their actual function is, I think this is an exercise that will be seen to have the same constitutional defects as the original setup. And if I may just speak briefly in support of the current setup, it is true that there are changes in policy, but that is a function of the appointment authority of the president, and he gets to appoint people. And this is not unique in terms of changes administration to administration. You see this in the field of antitrust enforcement. You see this in the field right now, the cutting back of enforcement of corporate corruption laws. You see this in many, many areas. When the president changes, there will be policy changes. And the statute allows for that in its current form. All of the prosecutorial and investigative functions are in the general counsel, who is removable by the president at will. The president gets to appoint the chairman, who sets the board's agenda and who shares with the general counsel the administrative functions. And individual board members, all they can do is what an individual circuit court judge could do, which is review appeals on the record and try and persuade their colleagues to agree with them. But they do it on the record. They do it cabined by the record in the case that's been made. And so an individual NLRB member doesn't even have the authority that an MSPB member has to issue, for example, a single member stay. The individual board member essentially can't do anything but vote on a case and attempt to persuade their fellow member. So the for cause requirement in the current law is what protects those people's independence. And just a brief thing more on policy oscillation, and then I'll turn it over to Glenn for his undoubtedly very contradictory to mine views. When I was the general counsel, I would always get hit with these questions about changes in the law. And I would try and make two fundamental points. The first is that the vast majority of cases are garden variety cases. The law hasn't changed, and they are adjudicated in the current process. And up until the recent underfunding of the board, they were adjudicated very efficiently, largely through the regional offices. The statistics have been the same over extended period of time, administration to administration. The merit factor in unfair labor practice charges hovers between 35 and 40%. That means 55 to 60% of the cases are disposed of without ever going to the board, number one, as non-meritorious. Unreviewable prosecutorial discretion by the general counsel. Number two, of the 35 to 40% of cases that do get merit determinations, between 90 and 95% of those cases are settled. Again, the general counsel's office, no going to the board, no opportunity to change the law, garden variety cases. It is the tip of the iceberg, and very few cases that get decided by the board. And of the cases that are decided by the board, the statistics over time are 80% of those cases are unanimous. The classic example, and Roger is well familiar with this, is the underlying unfair labor practice in the Noel Canning case. A black letter law case, despite the fact that the majority of the board at the time was Democratic, that was a majority Republican panel, with Sharon Block, unanimous, to Terry Flynn and Brian Hayes, unanimously found that the failure to sign a collective bargaining agreement was an 8A5 violation, black letter law violation. Ultimately found, after all the shenanigans about the recess appointments, et cetera, ultimately found to be an unfair labor practice and enforced. That is the typical case that goes through the board process. And the fact that there is, because of the changes in the political process and who appoints who and what Senate confirmation there is, that there are some changes that tend to respond to the policy priorities of the president, I would submit to you that that is no different in this context than in a lot of other contexts. So I have a couple of other things that I would say, but I've taken up enough time now and turn it over, Roger, to you and Glenn and the other panelists.
Thank you, Dick. Some excellent points. Glenn, you've been patiently standing by. Your thoughts?
First of all, thank you. Thank the Federalist Society. Thank the panelists. This is a fantastic discussion. As a labor lawyer, I wish we could talk about this for hours and hours, because we are really getting to the nub of what labor law is in the country. And I think this is very important. And I want to start with one disclaimer for myself. I'm speaking only for myself as a 40-plus year labor lawyer and not as a representative of the National Right to Work. So I'm not going to say what positions my employer might take on any of this, but I'll speak from the heart about myself and my view. So I want to commend all of you. As a labor lawyer who's done a lot of cases before the NLRB, elections, ULPs, objections, whatever they were, I'm constantly thinking to myself, there must be a better way to adjudicate this case. Why are we saddled by a trial by ambush process that was created 90 years ago? Or if this case was being tried in federal court, the case would look much different and it would proceed much faster. These are things that I say to myself all the time in my practice with NLRB cases. So I commend all of you for trying to think out of the box and look at ways to improve the process, because there's no question it needs to be improved. I want to state one overarching concern about the proposal before I get into a few specifics, and that is federal labor law, to me, is the most contentious area of law and policy that I can imagine. Maybe I'm wrong, and I know Dick said that, there's other areas of the law that are contentious with policy oscillation too, but I don't think securities lawyers or bankruptcy lawyers often find themselves in the midst of politically charged cases involving the president and the Senate. But it seems that labor law and the NLRB are magnets for politically contentious issues. There's a reason why quorum and recess appointment cases like New Process Steel and Noel Canning reached the Supreme Court under the NLRA and not the Department of Housing or the Department of Energy. And the reason is that presidents and Congress reflect what I'm going to call a political cage match that the NLRB and labor law brings. It sparks that kind of intensity. And I don't think there's any way around it to say that almost any changes to federal labor law inevitably become the third rail of American politics that no one wants to touch. And we've seen that with numerous efforts at reform over the years that have gone nowhere. I also want to recognize that not only is NLRA and NLRB reform definitely the third rail of American politics, I think this proposal to amend the adjudicatory process, which the proposal attempts to do, is itself a heavy lift that is unlikely to gain significant traction in the Senate, in Congress. And I think it's also unlikely to fix actually some of the major problems of policy oscillation. To me, a big part of the problem is the statute itself. Instead of Congress enacting clear statutes to set labor policy, Congress enacted vague statutes and created an agency to make federal labor policy, which sometimes gets done hurriedly and on the fly as NLRB members' terms expire. And I think we all know about the flurry of cases that come out at the last minute in the last days when members are leaving and one majority is going to shift to another. So it seems to me that if you have a serious effort at labor law reform, you need to address both the NLRB's procedures for adjudicating cases and the substance of the act itself. Now, I concede that that makes the heavy lift even a heavier lift, but in many ways, I see this proposal as not doing enough to really change what needs to be changed in the system. So that's an overview for me. As far as the actual policy proposal that you gentlemen have created, I think my biggest criticism initially is the independent, neutral experts that apparently you believe will break partisan ties and prevent radical policy swings. And to qualify as an independent member of this contemplated labor court, individuals must not have acted on behalf of either labor or management for 6 years. But I think this will so limit the pool of potential candidates to traditional neutrals like arbitrators and mediators and academics, no offense to the academics among us, I just think that there's not enough people who can fill that sort of role. It almost strikes me as a search for gods on Mount Olympus, people who are exceptionally wise and above the fray, but people who know enough about labor law but won't have significant policy leanings. I'm not sure those people exist. So that's my one concern about neutrals. I also think there's a real question about whether the judges under this Article I court can actually be shielded from presidential control. And I'm not going to discuss whether I think that's a good idea or a bad idea, because I actually think what Dick said, there's a lot of reasons to be concerned about presidential control to the micromanage level, especially when you're talking about adjudicators. So I don't want to get into that issue, but I do think that there's a real question as to whether this Article 1 court will be exercising executive power and not judicial power. And that means that they are going to be subject to removal by the president. And, I've looked at some of the cases, some of the older cases, Old Colony Trust and Justice Scalia's opinion in Freytag. And I think there's a very good argument to say that whatever you call it, even if you call it a court, and even if you call them judges, they're exercising policy in a way that makes it a function of the executive. And therefore, if Humphrey's executive is overruled, then these people are going to be removable at will. Again, I'm not saying if that's a good idea or a bad idea. And finally, I'm going to sum up by saying, while I think this proposal is great food for thought for all of us, in the course of thinking about this in preparation for today, I looked at a law review article that I've read many times over the years called Less is More, a case for structural reform of the NLRB. And it was written by Zev Eigen and Sandro Garofalo, 98 Minnesota Law Review, 1879, from May 2014. And I actually like their proposal a lot. And it does end up with cases going directly to federal court. And it does make the general counsel more like the EEOC in the sense of the general counsel can prosecute cases if he or she wants, or they could issue a right to sue letter and let private parties litigate. And I do recognize that what Sam said, you could argue that it cheapens Article 3 to make federal judges in charge of this. But I think there's ways around it. And one of the things that nobody's mentioned, which I think is important in this discussion, is Loper-Bright, because if federal judges don't have to defer to the board anymore, or they don't have to significantly defer to the board anymore, then why shouldn't the cases move quicker to neutral Article 3 federal judges who can help shape labor law in the absence of an NLRB? So with that, I'm going to take a break and stop.
Glenn, excellent points. Just a factual point on the independent number of qualified individuals. In doing some research, the National Academy of Arbitrators, which has very similar requirements to what the proposal is that we're discussing today, has over 400 individuals. The American Arbitration Association has many more. But we can discuss that at some point as we go through this really complex area of policy and law. Well, David, let me turn to you and then to Sam. How do you respond to Dick's points and Glenn's points?
Thanks, Roger. And I always, Dick and I have been in a lot of rooms. I always figure he's the smarter guy in the room than me all the time. So I hate disagreeing with him because he knows a lot and his experience speaks for itself. So, but here's a couple things that I think are concerning. Well, one is, if we're looking at Humphrey's executor, I don't believe that it's going to survive. We've seen the court on the shadow docket uphold termination after termination after termination in the last several months. I just don't see how we can say, let's wait and see, maybe this won't happen. So I just don't, to Sam's point, predictions never a great idea, but I think this one's fairly solid. So that's problem number one. I think that when we talk about, when Dick was explaining what members do, he was also saying what the general counsel working with the chair of the board. And I think right away, that's the problem. That what we have is the chair of the board is also working for the lead advocate in these cases. And that is what is raising red flags in the political spectrum. So, that's something that is just not going to fly in where we are right now. And in terms of the flip-flops that's that is kind of the normal course of law in many ways. I'm agreeing with Glenn. I think that the flip-flops, and while it is a small percentage of the cases, it's the cases that matter. It's the cases that we talk about, think about, and the changes are drastic. And they are really at, where the politicians come in and where the parties come in, which brings me to Glenn's point. Labor law has been labor law reform has been a failed promise of every Democratic administration, at least since Carter. And we can look at Carter wanted to revamp pretty much everything. All Clinton wanted to do was get rid of permanent replacements. Obama had
and the Team Act. And the Team Act. Yeah. Obama
had EFCA. Biden had the PRO Act, and we are still talking about, the law from 59, I guess, last major, major amendments. So I just don't see labor law reform happening. So I see us in some sort of level of what can we do, what works. We've got to live in the structure that this Supreme Court is taking us, and we have to make it work. And now to Glenn's point on federal court in relative to the EEOC, and that I just don't buy at all. And Glenn, and I'll say why, is first of all, if you look at the EEOC and discrimination in terms of adjudication, it is not something that we would ever say, hey, this is a great idea, let's follow it. We get close to 100,000 cases a year filed. The EEOC finds no merit in north of 80%, as opposed to, I think Dick gave statistics closer to 50-50, maybe a little lower than that, but not 15% of merit. The EEOC, in terms of the cases it takes, are in the neighborhood of 150 cases a year out of, again, the 100,000 that are filed. And the biggest issue here now is the expense and the time of federal court. The EEOC and discrimination law has employment lawyers who fill this void because of the money that can come out of discrimination law. There's attorney's fees for the prevailing party. We'd have to now change the law to allow fees for the prevailing party. And there are punitive damages. They're capped, but there's punitive damages under federal law. And then certain state and local laws have unlimited punitive damages. New York City has unlimited punitive damages, which again creates an incentive.
And class actions, David, as well.
What?
Class actions.
Yeah, but no, I mean, but New York just, a single plaintiff case has unlimited punitive damages. Anuka Brown Sanders versus the New York Knicks. So when you look and say, will this be something that will work in federal court? And now we'll have labor lawyers, firms like Dick's firms, Glenn, your group representing. I don't see the financial aspect to make it work for the firms. And I think that it just sort of, many of this major issues go away. And this court allows the NLRB's general counsel office to stay in this game and go for this court.
Can I make some points, Roger? I don't know if there's time.
Sam, hold on just 1 minute, please. Before we finish the EEOC analogy. So, David, would you suggest then that employees that have an alleged unfair labor practice case may have difficulty finding counsel to have their case pursued in a federal court that already has a overwhelmed docket?
Absolutely. They'll absolutely have trouble finding it. And the damages are back pay and reinstatement. And we know that in EEOC law, reinstatement happens approximately never. And in NLRB law, reinstatement happens a significant amount of time in things because it is valuable.
Even in the Title VII context, the 85,000 charges a year cannot find a lawyer.
Yeah, no, that's
not find a lawyer. And in the NLRB context, you want individuals to be able to access the machinery of that statute. It won't happen. unless we move to a tort model, as maybe people want.
But if we have a tort model, we're back to labor law reform. And Glenn, you referenced Zeb's article. Never want to criticize Zeb because, I love Zeb. But the issue is now back to labor law reform, like Sam's saying, which is asking basically to blow up the statute. And the last time we've had major reform in an employment statute, we're going to the Civil Rights Act. Well, Civil Rights Act of 1991, ADA, 1992, but a different time. Mm-hmm. George H.W. Bush signed those laws. That is unheard of now for bipartisan action on that. This is something that we hope can get bipartisan support because what it's doing is looking at adjudication and taking it away instead of something that would seem partisan.
Thanks.
Can I just jump back?
Sorry.
Sure, Glenn. Then I want to go to Sam. Sure.
Yeah, I'm not in favor of dismantling the general counsel system. As far as I do think the general counsel can issue complaints and litigate complaints, and we still have NLRB regional offices. And I think those things could happen even if the cases went to a federal judge as opposed to an ALJ. And I would hope that as somebody who represents individual employees, many of whom don't have lawyers and can't find lawyers unless they're lucky enough to find my organization or me or whatever, I think the general counsel prosecutorial system should work and should continue to work and represent people. But I also think there are cases where if they say our resources don't allow it or whatever, but there's merit, then the person can go forward. I mean, none of this is a panacea, and I hear you on all of this. And that's why I think this discussion is fantastic, because among all of us, we're bringing to bear all of these issues. If you were going to start from scratch and create a labor law, what would it look like? And I think that's what we're talking about. Now, whether it's ever going to happen or not, because of all the reasons that David just said, that nothing gets passed through Congress because the whole thing is so contentious. But I mean, I think it's the nature of the beast. Going back to the old cases like Steele and Hansen, the Supreme Court barely approved of exclusive representation and unions representing people because they said this is like giving governmental power to a private organization. So, these are very difficult societal issues, and I don't know if we're going to all solve them today, but I think it's wonderful to think about all.
Okay, I just 1 second just to jump in, and I just want to say your concept of the general counsel's office still litigating on behalf of the aggrieved party, in a world where the NLRB's budget gets reduced pretty much every year, the amount of resources that they would need to litigate in federal court as opposed to before the ALJ would be exponential. And again, I'm just trying to be a realist. They can run an ALJ. I mean, when I was a private practice lawyer, yeah, we'll try this case in front of an ALJ. What if it were in federal court? We got to settle this thing because it's just not worth it. And that's the fact as I see it.
Well, and I think though, just to
excuse me, Glenn. I will come back to you, but Sam's been waiting patiently.
Sure, sorry.
And I want to make sure we
this
get
is a great panel. I'm sort of responding to Dick. Dick says, wait for Humphrey's executor to go down. I think it is going to go down. The only thing that will save it if we make an argument today that these agencies like the MSPB and the NLRB, that they can sever these law enforcement functions. That's the only thing that's going to save it. And the justices, not all of them, but 5 of them, will understand the implications for other legislative courts and for the impact on judiciary. That is the only argument that's going to win. I know you've got this great amicus brief, Richard, on the original history and all that. The water's been under the bridge on this one. That's the only thing that's going to save it. Our proposal is in line with that notion. The MSPB should get rid of whatever law enforcement functions it has. That's ancient history. I want to preserve relatively neutral adjudication. And by the way, it will affect the 90% of the cases you and I agree are fact specific. If the president says, I don't want a complaint to go out against my company, it'll affect those as well.
I agree with you that the real danger of the president's ability to fire without restraint is not on the policy issues. The real danger is with respect to the garden variety cases against a big political contributor or against somebody that he has a prejudice against or whatever. I agree with you 100% on that. I think the policy cases are going to reflect, generally speaking, the policy of the president. I would just say, and Roger, just indulge me for a minute here.
Certainly, sure.
My father used to love to quote Yogi Berra, and I've inherited that. And there's the expression, it's not over till it's over. And I do think that because and I think Glenn made this point as well, I think because the proposal here, its viability is largely dependent on if Humphrey's executor goes down, how widely it goes down.
Yes.
Sam, to your point that, if it goes down with a severability and the rest of the statute goes forward, people will be looking over their shoulder, but the rest of the function will take place. Which is what has been the remedy in most of these cases where the single, they've just said that the president has the authority. So that's one thing. The other thing about the general counsel's office, David may have misunderstood what I meant. The general counsel's office works with the chairman in the administration of the agency, not in the handling of the merits of cases, not in a way that's dissimilar from the way the U.S. Attorney's Office and the Federal Public Defender's Office work with the district court in how to assign cases and how the functioning of the administration of the district court work. Number one. Number two, the notion of going into federal court where you have criminal dockets that take precedence, where you have insufficient judiciary, where you have the full panoply of discovery available to you. The one suggestion that has come up, which may be something that everybody here might want to think about, is that if the general counsel decides to proceed, the general counsel takes the case through the process. But if the general counsel doesn't find merit, then the individual can take the case, or the union or the employer can take the case through the board's administrative adjudicative process, much cheaper, expert judges, et cetera. If you took away, and I'm not advocating this, I'm just saying that this is one option people have suggested. If you took away the exclusive authority of the general counsel's office to proceed, and you gave people the opportunity to proceed through the cheaper adjudicative, administrative adjudicative process, less discovery, more informal, that might be a solution to this notion that there are people out there who don't get their chance. But the EEO model, with all due respect, is the slow boat to nowhere, as far as I'm concerned. And the notion that you're going to get attorney's fees for example, union requests for information cases, or a threat that doesn't result in a discipline, and that those are going to be adjudicated in an Article III court in any kind of a timely fashion, I just think it is an unlikely prospect.
Hey, Dick, just to jump in, sorry, Roger, Dick, part of our proposal is based on it gets laid out early. So sticking with the Yogi line, that if we wait for Humphreys to go down, it may have gotten late. It got late before it got early. Sorry, Roger.
No, understood. So I think there's some elements of agreement here, or levels of agreement. The proposal for an Article I court keeps intact the entire general counsel structure and does not remove the authority of the general counsel to run the regions, to process our cases, and to file complaints. So that part of the act would stay intact as we understand it. Sam, back to you. This issue of whether an Article I court can survive a president's interference and permit the president to remove a judge for any reason or no reason. How do you respond to that?
Well, it'll imperil the entire Article I court process. We haven't seen it yet. Freytag, by the way, in the majority decision, said it was a judicial process, the tax court in that case. Now, Scalia disagreed in dissent. Scalia has a lot of influence, but if they get rid of all the Article I courts, it means they either have to be in Article III courts or in some tribunal, as we had in the old days, where basically the president's people decide. And that seems untenable to me. I think it's only untenable to the court if we make that clear. Arguing about Humphrey's executor, they've already gone, they're finished with Humphrey's executor. You have to make other arguments. They think they can distinguish the Federal Reserve Board. Maybe they can, but they've got to think about the consequences for the overall system. Even though the chief has been behind us, unitary executive concept, he's also got to worry about the impact on the Article III judiciary, which will be very, very serious.
Thank you, Sam. And Glenn, I know I cut you off. I apologize. I want to come back to you. You had a point you wanted to make.
No, that's okay. This is great, really a great discussion, because I agree with what you were saying. I mean, I would want the general counsel process to remain intact. And, most NLRB cases settle somewhere along the line. Not every one of these cases is going to go flooding into a federal court. And the routine cases that have merit, those get settled all the time too. So we're really talking about a small subset that would actually get into federal court. And I think federal courts are great at managing their dockets and everything. So I think they could figure it out. I mean, they get Social Security cases and plenty of other cases, and they can create local rules to manage the dockets. If this became a problem, I don't think it would become a problem.
Social Security cases are adjudicated. They're agency adjudications now. You in the courts, but they're agency adjudications.
But let me just throw one other thought out, because again, I'm the only person that mentioned Loper Bright in this discussion, and I'm curious to know what people think about if Loper Bright really says that federal courts don't have to defer particularly, and we can argue about how much deference, if any, remains. In fact, I was told that at Big Sky, there was a discussion with Judge Sutton and Judge Garcia about that issue. But so the question is, if federal courts don't particularly have to defer to the NLRB, then why shouldn't the key cases get to a federal court quicker? I'll just throw that out.
Can I try that, Roger?
Yeah, absolutely. Please.
First of all, there are lots of rules or policies that the board has that will end up being deferred to under Skidmore or whatever. They're long-standing rules. It makes no sense for the courts to come up with their own contract bar rule, with their own, even though I disagree with the board on this, their own blocking charge rules. If that's the case, by the way, we have a system. If in fact they are going to overturn all of these decisions, then we have a system that we might as well be in Article 3. It'll be every case discovery. You saw what happened in the Starbucks litigation with discovery and 10J. That 10J injunction went nowhere. So in my view, the system breaks down. You have to either under Skidmore or because, and the court left this open, there's a delegation of interpretive authority. What are we going to decide with employee access to an employer's plant? Are we going to revisit all these issues, making them takings clause issues? I think there's a parade of horrible that awaits us.
Since Glenn got to recommend the law review article, I'm going to recommend a law review article on this subject, which is a recent article by Fred Jacob, who teaches at George Washington University Law School and also is the board's current solicitor, and Anne-Marie Lafaso, who now is at the University of Cincinnati Law School. They've written an article about what they characterize as the iterative board decision-making process and why it is that the courts should pay attention and give, whether it's characterized as deference or some other consideration. It's a very thoughtful article. It's by two people who are intimately knowledgeable about the board's processes, and I would highly recommend it.
Thank you. So one of the responses that I have heard to the Article 1 court is, yes, there is a very small percentage of cases, as Dick mentioned, that are so-called policy cases that are decided by the board. But those cases, as suggested by at least two colleagues, have a very strong ripple effect on board law, on the so-called garden variety cases, and indeed become an important part of the overall jurisprudence of the board. So while they may be a small percentage of the cases decided at any one time, their influence on the entire inventory of board cases is quite considerable. So the percentage issue, these colleagues suggest, is really not a strong argument against some type of important reform here because of their overall impact. So let me go back to this issue, however, of independence. Sam, how do you respond to whether we can find independent individuals for your proposal?
You made the point about the National Academy of Arbitrators. Where they're using the same criteria. Arbitrators will find, I think they will find us an attractive position. And over the course of time, if they want to have any influence on this labor court, they're going to have to show themselves to be not predictable, but actually take each case on its merits. That's part of the process when you have collegial courts. It'll be a collegial court in that sense. Now, sure, the president may make mistakes, maybe people that are ideologues, but in general, the neutrals will, I think, over time will play that restraining voice. I don't think that's naive on my part. Initially, we don't know, but over time, if they want to have influence, they will have to actually be fair adjudicators for the D's and the R's in those cases. Academics, I think, first of all, I think we got a question and answer about political registration. I think we initially thought that political registration, party registration should be disqualifying. We no longer do, because then we are really looking for a unicorn, someone who knows labor law, labor management relations, and has never even registered as a Democrat. I've been a lifelong independent since I ran election districts for John Lindsay, and I've now become a Democrat because I wanted to vote in the New York City primary. So I think that's highly disqualifying. Most academics, I think, will not be, because many of them in this field are in fact very active in amicus brief writing, representing a labor or management interest. I think they will not be, but there may be others, retired judges. There are some practitioners that have developed a reputation, even though they may not be very active arbitrators, but they've developed a reputation for being fair shooters. It's hard to say, but I think we will find enough people for that job. It'd be a great job for some of these folks.
Well, if I could just make...
Oh, Dick, please, yes.
And I'm not trying to be... I think it's extremely important when somebody gets into one of these jobs that they take off their prior hat and make decisions based on the law and the facts in front of them.
Right.
I would say, though, that if you look at Article 3 judges, get lifetime tenure. There's no such restrictions on who gets to be an Article 3 judge. You have many prosecutors who end up presiding over criminal trials as Article 3 judges. You have many public defenders, not so many, but some public defenders who end up as high as the Supreme Court. And so I just think, I'd hate to think that our labor management community is incapable of producing individuals who are capable, whatever their prior experience is, from stepping into the job. And I've had this conversation with Craig Becker on a number of occasions. His question always to people is, tell me the decision you made that was directly contrary to the interests of your constituency group. and that's the test of whether somebody really is capable of being an independent,
a good test,
adjudicator. And so I understand there's problems with neutrals. I have questions about, getting some, although I don't doubt that if you included NLRB regional directors, et cetera, there would be enough or career people. There'd be a body that could be drawn from. I just question the initial premise that you need to cabin the president's authority to appoint in this manner. And that people from the greater labor management community can't be appropriate for holding these positions, even the central one. I also think it's going to be very difficult, and we've seen this in the Federal Election Commission, the way it's structured. It's going to be trying to engineer a neutral structure that actually makes decisions in tough cases is an interesting proposition.
Yeah, fair point. Marco, I do not have access to the questions, unfortunately, on my laptop. Would you state questions that we have not covered? I want to make sure our attendees have a voice in our discussion.
Sure, absolutely. John Scheller asks, has the proposal been floated among any members of Congress yet? And if so, what is their reaction?
Well, I'm going to violate what I said, Marco, at the beginning. I have been involved in discussions with members of Congress and their staff. We've also had discussions with various stakeholders, both on the labor side and the management side. And the reaction overall has been, frankly, quite positive. Now, like anything else in Washington, and this has been alluded to, it takes a sense of urgency to have anything of significance happen. And we think that sense of urgency would be a overruling of Humphrey's executor. So in sum, the reaction to date has been much more positive than we thought. Marco, other questions?
Rog Candelara asks, is any judicial power vested in the executive branch?
Sam?
It's a good question. Congress can set up administrative tribunals and put them under the control of the president. I guess there's an exercise of judicial power there. It's a good question. The old answer of the Supreme Court was, and I think it's still true, that if there is Article III recourse at the very end of the process, the judicial power is preserved. It can be farmed out, as it were, to other adjudicative bodies. This goes back to an early case involving the Merchant Marine. Just forgotten the name of the case for a moment. Where the court tried to curb delegation to other bodies and into a doctrine called the jurisdictional fact doctrine, and that went by the boards. So currently, Article 3, as long as an Article 3 tribunal is at the end of the process and can review it, then it comports with Article 3 that adjudicative authorities are outside of Article 3. If in fact I'm not right about that, then these legislative tribunals, which some of them have been affirmed by the Supreme Court, are also in trouble. Now, you could argue that many of these legislative courts involve special things, claims against the government, public rights. So there may be an argument for preserving some of the legislative courts. But if we have this view that all judicial power has to be in Article 3 judges, then I think there's going to be a lot more work for Article 3 judges than is currently the case.
I would just note the proposal that's before us today does have appellate review from the Article 1 court to the Article 3 court. Yes. That's the way Article 1 courts operate, and that's required under the Article 1 constitutional structure. So that concept has been preserved. Marco, other questions?
James Young asks, won't the proposal for neutrals suffer the same fate of the notion of neutral arbitrators, that they would be captured by the labor management dichotomy, ignoring the fact that the Act vests rights in neither, but only employees, and gives the example of Lechmere?
David?
Marco, can you say that one more time?
The questioner is asking, would the proposal for neutrals suffer the same fate of the notion of neutral arbitrators, that they would be captured by the labor management dichotomy, ignoring the fact that the Act vests rights in neither, but only in employees, i.e. Lechmere?
I mean, I'm not sure where Lechmere comes out of this, but the question is, we're dancing around this. To Dick's point at the beginning, which is to say, people who go on this court should leave their private practice at the door and act righteously. Now what we're saying is, can we find two people who will come in the country, who will come in as neutrals, who will be deciding the cases based on what the law is and not being influenced by who they represented in their past, or who they wrote about, or if they were arbitrators, which parties they were in favor of or against in cases. And I just hope that of all the labor lawyers that we know, and we know a ton of them, that we can find two, especially those that are arbitrators who have made their careers being neutrals, that we can find two that will come in that won't be seen as compromised as they take the job.
I want to repeat the point I made earlier. Maybe on a one shot, the person comes in with the priors, but to be a credible person in a collegial court, you've got to acquire a kind of neutrality in order to be effective and influential in the court setting. They're going to be outliers, but most of the judges, if they take this job, they want to be influential. They're going to have to. We want to pick people who will have that frame of mind, and I think they will have that frame of mind.
I hate to beat a drum, but Sam, that's the way you're effective as a board member in the current system as well. I just want to take issue with Brother Young's point. There are rights for labor organizations under the statute, as well as rights for employees.
That's true.
And so it's not just employees who have rights, although primarily Section 7 protects the rights of employees. And employers have rights under the statute too. Respectfully, it's a statute that has many pieces to it. And I'd hate to think that you would lose the expertise of people who have experience with this because you are too selective about what the criteria are, or you send it to federal district court judges who, in my recent experience, know absolutely nothing about labor law.
That's true.
Good point.
But that might be a
very good point.
On some of these issues, that might be a good thing, especially if Loper Bright means that the deference to the board on substantive matters is much, much less. But I would like to inject maybe we're getting towards the end, far be it from me to say that this is over, because it's a fantastic discussion, I think. But I have to almost laugh listening to David, because it reminds me of the story in the Bible of Abraham arguing with God about if there's even 5 people in Sodom, you should save it, or if there's only 2, or what about
it had a biblical ring to it. It did.
Right. So listening to David, it's sort of like, can we find that one neutral who will save all of us? So, I actually don't. I'm not enamored with the idea of searching for neutrals who are going to come in on a white horse and save the day. To me, elections have consequences, as we've heard for the last long period of years, and policy shifts may be what democracy is all about. Maybe it's an ugly thing, but it's a fact. So that's going to be my conclusion. And I think we lost Roger.
Yeah, but Glenn, I'll come back because we keep flowing back and forth, and I appreciate what you said. When we were talking about how are we going to find these people, I kept thinking about Little League Baseball when you had 0-2 count on you, and they'd say it only takes one to get a hit out of this. In the country, it only takes two. I'm not looking for the white horse. I'm believing that there's hundreds of qualified people for the job. Roger's not here. I'm going to give my last word, and maybe we'll just do that around the panel, and then because I know we are bleeding over. And as we're citing law review articles, Myron Rubkin wrote an article probably 40 years ago, but it's true today, which is that delay helps employers. A day helps employers. And when we start looking at an adjudication system that has inherent delays, then one side is benefiting from it. And I also think that the system breaks down. What makes the NLRB being able to work, and we can argue whether the flip-flopping has been problematic or not, but what makes it work is that it moves relatively quickly, and federal court does not. And if we send it in there, I can imagine employers enjoying the process of delays of years and years and years. So we need something that's administrative to get through this. If not our proposal, something else, but we've got to figure out to do it through the agency.
Good point. Marco, I lost power completely, so I backed out. Did we extinguish all the questions?
There are a few left, but since we're a few minutes over, I want to be respectful of everyone's time, including the panelists and our audience.
Well,
Roger, while you were gone, I gave my last word. So,
all right. Well, let's just wrap it up. We are over time, and we could certainly go much longer. Parting comment. Let me go in reverse order. Glenn, quickly.
I gave my pretty much close while you were cut out. I just want to respond to David there at the end. Delay helps whoever is using the delay. My clients who are trying to get decertifications in the face of blocking charges and other things like that are victims of massive delay in the agency right now. So not to get into the whole substance of things, but delay is inevitable in almost any system that we have in this country, unfortunately. And my final word is thank you all. Fantastic discussion. We should continue.
We will. Dick?
Yeah, I want to second Glenn in terms of appreciating the opportunity to have a candid discussion. And I just want to make a pitch for the notion that if people are really, and I agree with Sam about the Chief Justice needs to be concerned about the impact of this on judicial independence, the consideration of Humphrey's executor, the consideration of firing without cause. And so I think to the extent anybody wants to be useful to in the cause of continuing quasi-judicial independence at the National Labor Relations Board, file an amicus brief in the Wilcox case at the next step.
Thank you, Dick, and thanks for your time today. Sam?
I intend to file such a brief. This proposal of ours becomes more attractive after Humphrey's executor if it comes down with a relatively narrow decision. Then I think you're all going to become adherents to this proposal. And I'm not hoping for that day. I'm hoping we convince the court that a narrow opinion which preserves an adjudicative process that is largely and principally adjudicatory should survive their ruling. They should be concerned about it. It's not just the Federal Reserve what they should be concerned about. They should be concerned about the complete demise of the legislative court model that's been out there from many decades.
Thank you, Sam. Thanks again to all panelists. Let me turn to you, Marco, but I want to thank the attendees for bearing with us. We will come back to this, and as a member of the Federalist Society Labor and Employment Executive Committee, I know this will be an issue that our committee will continue to closely consider.
Thank you, Marco. Thank you, all of you panelists. Terrific.
Thanks, everybody.
Marco, back
Thank
to you.
you. Yes, absolutely. I just want to second the thanks for all of our wonderful panelists here today. This has been a fantastic discussion, and also our audience for our attendance and participation. For more information on upcoming events, please visit our website or all major social media platforms at FedSoc. On that note, we are adjourned. Thank you again.
Thank you for listening to this episode of FedSoc Forums, a podcast of the Federal Society's practice groups. For more information about the Federal Society, the practice groups, and to become a Federal Society member, please visit our website at fedsoc.org.